Hello, everyone. If you can hear me, this is JJ Arisha with Pismo Ventures. We're going live. We're going to stream live on both LinkedIn and YouTube. You should be able to uh, see see us on LinkedIn right now live. Also, the same applies to YouTube. There's a link for YouTube. If for some reason you're not able to participate on LinkedIn where you're able to ask questions, please feel free to go to the LinkedIn at the YouTube link that is also in the LinkedIn Live event description. Um, we will start in a couple minutes. We'll wait here until we get some people joining us, and we'll get started. Um, I have with me today two of my best friends and colleagues. I have Kwan with NTIP Patent Law Firm, and I have Ken August with the August Law Group. So, Kwan, maybe you can give us a minute or two about you.
Oh, sure. Hello, everybody out there. I am beaming to you from my mobile office. So JJ was giving me a hard time about beaming out from my car, and I was saying, this is the startup world. We're mobile. We're flexible. We're nimble, and so here I am. When in Rome, dress like Romans. So we are in Rome. We are in startup world, and I am dressed like one. Good to see all of you all. Good to be with all of you today.
There you go. Hey, Oscar, shout out to you. Thank you for joining. Ken, give us a couple of minutes.
Good morning, everybody. It's nice to see you. Um, August Law Group is a transactional boutique. We focus on all manner of corporate transactions, corporate governance, and particularly enjoy working with teams to build startup companies and new companies, as well as help established companies to expand and to grow internationally. Great to be here.
Thanks, Ken, very much. So I might be looking right and left because I have a couple of screens here and I'm trying to monitor everybody that's joining. So today, just a little bit about me, JJ Arisha with Pismo Ventures, a venture firms and studio, venture studio here in Irvine, California. Although we, for the past few years, we have had a national footprint. We help startups from ideations all the way to raising capital and potentially exit, like everyone wants. Um, and the reason we called the firm Pismo because Pismo is a good beach, and you can always sit on the beach after you exit. So there you go. All right. So today, if we don't have a specific questions, this is an open forum. It's lunch and learn, but you can ask about anything you want. But today, our theme for Kwan is due diligence. So we're going to talk about due diligence today from different angles. Due diligence when it comes to IP or patent law, when it comes to corporate, and when it comes to the actual raising capital and what angel investors do when it comes to due diligence. So it's really a lot to unpack. I welcome for everybody to join in and be part of this conversation. And maybe what we'll do is we'll ask Kwan about his idea of what is um, due diligence when it comes to patent law or IP in general.
Sure, sure. So I love the forum that we have here, that we have representation from probably the three most important categories for a due diligence. One is IP, two is corporate law structures, and so on and so forth, and three is business. So I'm often asked. We represent a number of investors, and I'm often asked. To do a due diligence of the company that they are interested in investing in. And typically, they're interested in a number of things. But let me just start out with this. It depends on the dollar amount that they're going to be investing in. If it's well, usually at the seed level, the friends and family and fools, there's hardly any due diligence. And at the angel level, there's some due diligence. It ranges a little bit. And then when you go to the VC and the acquisition partners, and it gets more intense. So let's define due diligence. Due diligence for the IP, or in particular the patent, is checking out to see if the several things. Number one is whether the company actually owns the IP that they say that they do or not. Okay, so that we look through the chain of title. From the original inventor all the way to tracing it all the way to the company and making sure that there is title. Number two is, okay, these patent things, are they patent pending or are they issued patents? Those are two different things altogether. A lot of times people would say, I have a patent on something, but not really. They have a patent application on something, so it is pending at the time. So then, depending on whether it's a patent or an issued patent, you look for whether there is patentability. If it's just a pending stage, you project to see whether, they asked me to project to see whether there is a good opportunity, good chance, good likelihood that the application is going to mature into a patent or not. And that is looking at the prior art. If it is an issued patent, then you look into whether there is any issue of validity, whether it's going to be challenged, and if it is challenged, whether it can withstand the challenge and still be a valid patent. In either case, the analysis is looking at prior art to see whether there is anything that was filed or existed before the filing date of the application or the issued patent, and consider the patentability or the validity of the patent or the patent application. Okay, and the third thing that is often asked is, okay, patent or no patent, does it matter? If the company is going to make this widget, or if the company is going to implement this algorithm, will they be infringing on any third-party existing patents? And that's called a freedom to operate. And typically, we look at those things. And IP is really important, especially for the early stage, because at the early stage, usually there's no customer, usually there's no inventory, usually there's no physical build out of anything. So the asset and the value of the company is very much in the IP itself. And at times, it could be said that the early stages, IP is worth about, in terms of appraisal and valuation, is worth about 90% of the company because there's nothing else. So in a nutshell, that's what it is. And I want to just put those topics on the table, but then I want to give Ken a chance to also talk about the due diligence issues that he looks at, and then we'll dig into some of these in more details. All right, go ahead, Ken.
So when we work on pretty much any transaction, whether it's an acquisition, an investment transaction, a joint venture, we always have a due diligence process. And what I find is that the trick to due diligence is making sure that you have a very organized and comprehensive way to do it. So when we do it, we have a due diligence questionnaire, which has all of the items of categories of things that we need to look at to make sure that the company has what they say they have and what they need to have to operate to protect our client. And then we usually will have them populated into a Dropbox or some other shared storage facility. And then everybody has access to it that's granted permission to look at it. And you line it up so that the numbers on the folders in the shared storage match the numbers on the questionnaire. And it makes it very easy for people to look at things. What I find is that, as you were alluding to, Quan, sometimes people have been operating their businesses for long periods of time, and they believe certain things to be true. But when you really get into the nuts and bolts of the due diligence, you can find that it may not be what they thought. And I remember there was one transaction I was working on. It was, hundreds of millions of dollars transaction, and one of the core pieces of their operations was a particular license. And when we actually drilled down and had them produce the actual license agreement, we found out that it wasn't fully signed. So they were working on a license that wasn't executed. And obviously that's a risk to anybody that's investing in or buying that company. And those are the kinds of things that really make due diligence important. And so we urge our clients to go through the process in advance of a transaction where somebody else is looking at it, so that they know from nuts to bolts that everything is clear, everything is there that needs to be there. There aren't any holes that are going to come up and potentially kill a transaction while it's in process.
JJ, any thoughts on the business strategy in terms of presenting everything ready to go for due diligence on your site?
Well, that's when it comes to the due diligence, as an angel investor, and as we look at the any company that's looking to raise capital, what we do is we really look at everything, starting with freedom to operate. if they have a patent, or they're filing for a patent, have they done their homework? Um, so there is a process um, um, that we go through at Pismo Ventures to help companies be prepared for that due diligence process that they would go through when it comes to the investors, either VCs, micro VCs, angels, or anyone who's looking to invest in them. They're going to ask them a question. So, some of the things, sometimes people don't think about this, but one of them is, do you have a history, a criminal history? So we, they need to be, if they do, they need to be very straight and upfront about it. If they have any kind of record, and I've seen it time and again where people just say, you know what, I was this and I did a dumb thing, but here it is, and they're pretty upfront about it, and that's how it needs to be. So background check is one of those things that we look at. We look at, then we go deep into the for example, the go to market strategy, how you're gonna get to your customer. We go into the financial due diligence. We look at their finances, and we make sure that the financials projections are correct, and their the assumptions around these financial projections are the right assumptions. And a lot of times, what happens is, I see this so much more than many times than you think, and that is, they try to use their capital raise as part of their revenue, and they show that on their in their projections as revenue instead of capital raise, and then they calculate it as part of their EBITDA, and they're as part of, so which doesn't make any sense. So that's really that tells the investor that maybe this startup, they need maybe a part-time CFO or someone who can help them with this process. So we talk to their customers, because when they go to have due diligence with an investor, that investor is going to talk to that customer. So they're going to pick 3, 4, 5 customers. We talk to them as well and make sure that these are the right customers, and they have the right answers to the right questions, because it's very easy for any investor to pick up on something that's not real, or that's not correct, or if someone is trying to work around having a customer and they really don't have a customer, or having sales and they really don't have sales. And so we go through the process from beginning to end, looking at every aspect of the business, from sales, marketing, talking to customers, background, um, the team. Also, the team is really important. Sometimes what I've seen is, they put advisors or board members on their slide deck, and they're not really part of their board or part of their advisory. And then you pick up the phone, or you look that person up and you call them and you say, how long you've been advising. Oh, I haven't been. Why? Well, you're on their deck. Well, I shouldn't be. These things really, you do want to, as investors are looking for one thing to say no, right? So if they find one thing to say no, they're going to say no. So it's really important um, to make sure the companies are really straightforward about what they're doing. They don't need to oversell. If they have a product or service that's really great, it's going to come out, and the due diligence will show it, and the investors are happy to invest. So I hope that answers some of the questions. I'm sure we can talk about this for the next 3 days, but this would be maybe a little bit of an idea. We have some questions for you. We'll start with Todd. Kwan, it looks like there's a question. I'll put it up on the screen. I can do
Sure.
that. How about that? Here we go.
What is the best approach in determining whether IP should be filed for patent protection versus keeping IP as a trade secret? Enforceability is one. So enforceability is this: is when you have a patent, can you detect that someone else is practicing what you have patented to enforce it? So I don't know, maybe the word detectability or enforceability, same thing, but it goes together in that way. Here's an example. If you have a software that runs and produces an output, and the output is the product being sold or the service being sold, and let's say you have a patent on that algorithm for the software, and a competitor begins to put out products similar to yours or the same as yours, there's no way that you can tell whether they've used the same algorithm as you or not. That's going to be hard. So detectability and enforcement is one. The other consideration is whether if you're going to keep something a trade secret. Let's say that, okay, so you can't really you shouldn't really patent this algorithm or process, because there's no way that you can detect it if someone is working out of their basement and cheating you, and you'll never be able to prove that they're actually using the algorithm. And let's say you're going to keep it a trade secret. Let's say you have something as a trade secret. The consideration for whether you should have something as a trade secret would be um, reverse engineering, the ability for someone to reverse engineer your trade secret. If it is something that is very easy to reverse engineer, then maybe you shouldn't keep it a trade secret, because if the trade secret is reverse engineered, someone does it, you can't do anything about it. That's just the way it is. So those are the two considerations: detectability, enforceability for patenting, and reverse engineering, the ease of reverse engineering. If it's so easy to reverse engineering, then you shouldn't keep it a trade secret. Hope that answers your question.
Great answer. Todd, you can follow on with another question if you have. Meanwhile, we'll answer Mohan's question. I don't know if you, uh, maybe Ken, if you know anyone locally for printed circuit boards. I used to do. I don't have anyone right now, but I will probably look into my contacts and see if there's anyone. But there are a couple in Orange County, from what I know. If anyone knows, Ken Kwan.
Yeah, I used to have a client that that did that work here in Orange County. I don't know if they're still around doing that, but I could check and see if anything comes up. We could contact Mohan by LinkedIn.
Yep, Mohan will reach you by LinkedIn. You can always feel free to reach out to us. I think we have our emails here. You can reach out to us via email as well. Um, any other questions? Please feel free to do so while we are continuing on the due diligence. Ken, you and I talked about due diligence many times. Um, I know you talked a little bit right now about that, but can you maybe expand into when you do due diligence on behalf of a investor, what kind of process do you go through?
Of course. So, due diligence really is a tool that we use to try to mitigate the risk of entering into a transaction. And so the process is a prism that we look through to say, okay, what do we need to do to confirm that what the investor has been told about the target company is accurate? Are there any traps that they haven't been told about? Can we find them, unearth them through the due diligence process? And is there anything that sometimes you in going through the review of due diligence materials, you may find things that the target didn't know about, or that may be relevant for tax reasons or other reasons to the investor that may not have been relevant to the target company as a standalone company. So it's really just trying to review, and I break it into really two parts: a financial due diligence, which can be anything from just simply reviewing financial statements to really going to some sort of a comprehensive quality of earnings type analysis on the company. And then a legal due diligence, which just says, okay, I want to see every contract that you've got. I want to take a look at your corporate governance materials to make sure that you've been in compliance. I want to see that you've complied with all state and federal securities regulations from the issuance of your stock, and kind of follow that through. That's a very big trap sometimes. And just make sure that we don't see anything that we feel adds a degree of risk to a transaction that either is a deal killer, or just where that risk needs to be baked into the pricing and the negotiations a little bit more.
Very interesting. Go ahead, Kwan, please.
Chairs in the way. There you go. Okay, so guys, I often get answers back from the target company, or the startup, where it doesn't make any sense. And to be fair to them, I try to see whether it is intentional deception or it's just simple, silly misunderstanding, and because there's just so many areas of expertise that the start the CEO has to tap into, and sometimes to get it wrong. I'll give you an example. A very simple one is they said they have 5 patents. Well, they don't. They have 5 pending applications, and then that is really 1 core patent and then 4 foreign filing countries. So it's really 1 family. So the representations that are incorrect, I try to assess whether it's an intentional deception or just a simple innocent mistake. And so question for you guys is actually 2 questions. What do you do when you encounter situations like that? And secondly, what advice do you have for the startups in preparation for a due diligence to avoid making silly mistakes like that, but also at the same time, if they do, prepare themselves for a reasonable explanation so that they can get through that and not be shut down because of this one particular thing that they supposedly misrepresented? Do you have any suggestions for the startups out there?
Ken,
Well,
go for it. Yeah.
yeah, I mean, as I said before, I think it's a good it's a best practice really to get your due diligence materials up into a room and have somebody like me or somebody else go through it and make sure before you ever give access to it to an investor or to a potential acquirer, just to make sure that there isn't anything in there that could be a problem or that needs to be explained, because oftentimes you can preemptively handle issues by bringing them to the fore and having a good answer, or they can be corrected, and you can take care of something before it becomes an issue that could really be harmful to a deal. The point of the point that I think we need to remember is it's not just about providing due diligence materials, but your transactional agreement is going to have a section in it called representations and warranties. And what it says is that you are making disclosures that your investor or your acquirer are relying on as being true and accurate and complete. And that's the inducement for them to give you either the investment capital or to buy the company. And so the due diligence really is just the backup for those reps and warranties. And so what needs to be done is a full circle analysis to make sure that there's nothing in the reps and warranties that can be crossed up by not having due diligence that supports it, or more importantly, that contradicts what those reps and warranties are. And that ought to be done completely internally with professionals before anybody that is a transactional partner steps into the arena to look at it.
I don't have anything else to add to that. I think that's really about right. So
Yeah.
um,
So what I'm hearing is you want to bring in eyes. You want to bring in extra eyes to stare at it before it goes live,
Mhm.
basically, right? And those eyes, as much as you can, because there's so many areas of expertise. There's IP, there's corporate, there's finance, and so on and so forth. So you want to bring in the right people to have eyes on those particular areas before you go live. That's really good recommendation.
I will add to that. So we're talking about maybe due diligence when an investor, an angel group, or a VC is looking to make an investment, and or maybe someone looking to acquire. But I would say you probably should do all this before you even go pitch or try to sell your company. Uh, Try to have your ducks in a row ahead of time.
Absolutely. Absolutely.
It's not at the time after someone says, "Oh, now I'm interested," and you go put it in a deal room and then you start answering questions, because you might already mess up before you get there.
Well, to that point, JJ, the one common thing that I often hear from my clients is uh, after the fact, I can't believe how much work it was to get through the due diligence, or I can't believe how many documents you asked me to provide. And some of them I haven't seen in 15 years, and I had to really go back and find them. But they're critical pieces of proving, as was mentioned before, either the chain of title to something, or just that you've got the necessary legal elements that you need to be able to be conducting the business as you're conducting it. And so even for a startup, which is a relatively new company, there are so many different facets that you definitely have to do it in advance, because it's not just a question of what you have, but it's also a question of figuring out what you don't have, which can sometimes be even more elusive and can be as much of a problem when the real due diligence is being done as something that you have that's incorrect.
I'll give a quick example without mentioning any names. So there was this company. This is probably 15 years ago. This company was trying to sell, and a huge conglomerate was paying them $180 million for their technology, and they had everything in place. And this huge company did end up buying them for 180 million. and the entire process from beginning to end was about a 3 months period, which is like extremely fast
Yeah.
for some huge company to buy. But then about 3 months after that, this company wrote off this business and shut it down
Mm.
because another huge company uh, released a product into the marketplace that killed, um, what they just bought. And the reason I'm mentioning this, because if that process had taken longer, then that transaction would not have gone through. Because on average, it takes 6 to 9 months, maybe a year, for a potential acquisition to take place. But this acquisition took place in about 3 months because they had all their ducks in a row, and they ended up making a lot of money. But if that transaction had taken just a little bit longer, um, the acquirer would have known at the time that this other huge company was releasing the same product into the marketplace and wouldn't have bought it. So being ready is very important, regardless if you're trying to raise capital or you're trying to actually sell, um, uh, because you don't know what's hidden, what's in the marketplace, that's potentially in this situation that's coming out that could kill a deal.
Yeah, that's a beautiful example, JJ. I mean, so in that particular case, there, the company was together, they did a good job, they lucked out, but also at the same time, the company could miss out on opportunities. The startup could miss out on opportunities because investors are human, and they're bombarded with every minute 25 opportunities to invest in something. And then if they are interested in this one company and it takes a long time for things to come back, the interest is going to begin to erode, and eventually it's like, oh, never mind. So the longer it takes, the more risk the startup is going to have in the investor losing interest. Ken, you're about to say something. I cut in. Sorry.
No, I
Oh,
agree. I was just going to say that the other side of that coin, or what JJ's story really points out, is that um, the competitive arena is an important part of the due diligence process. And a lot of people don't look at that as due diligence because it's not quite as tangible as documents that you can put your hand on, but it's very much an important analysis as part of the due diligence.
Kwan, there's I think, an interesting question here from Mohan.
Is it smart to manufacture my product in China where I would not have IP protection, but a lot cheaper? Yes, it could be. So the story with that is that patents is jurisdictional. That's what it is all about. Patent is jurisdictional. And what that means is that if you have a patent in the United States, you are protected only in the United States, and as you know that. In China, and protected only in China. But more than that, let's say you have a patent only in the United States and you manufacture out of China. Well, as soon as a competitor, competitor can do the same thing. They can sell in China and they can manufacture in China. But as soon as a competitor begins to sell your product crossing the U.S. border, that's where you have rights. That's where you have rights. So then, should you spend the money to file in foreign jurisdictions? The sky's the limit. You're looking at China, Japan, Europe, Canada, Australia. The sky's the limit, right? So what you want to do is you want to prioritize and look at your market cap. There are two considerations when you want to look at which countries to go into or to file your patent application into. Number one is, what is your market cap, your market opportunity in that country, that jurisdiction. If China is a huge one, by all means go in China. There's some discussions about that. But let's say Canada is a large market cap opportunity for you, then go there. Now, the other thing is manufacturing. So we have nowadays, it's not just China anymore, but you've got Thailand manufacturing, you've got Vietnam manufacturing, you've got a number of other potential countries that are manufacturing. And then that is a second consideration as to whether you should or should not file patent in that country. Market opportunity and manufacturing. Now, I can tell you this. Trademark is a little cheaper. So if you have a product that is more of a consumer product, to the mass market where the brand matters. If you have like a niche market where you sell it to a B2B, business to business, trademark is not important. But if you have a consumer product, trademark is really important. We have this situation. So it is this particular product is a multi-million, in the tens and $20 million revenue. This product here, it is manufactured out of China, and because it is a consumer product, the brand is etched onto the product itself. Out of China, there's an outfit that filed a trademark on that brand, not a patent, a trademark, and they can do that. Okay. And then as soon as they did that, then it created a lot of problem because the manufacturer happened to be in China for this particular company. And so they receive a cease and desist and so on and so forth, and a demand to pay a lot of money in order to continue to print their name, in which they came up with, but did not trademark in China. So that's a consideration for you. Not so much as in patent. Let's see, you asked about IP. Okay, so IP includes patent and trademark. For patent, the considerations I gave you before. For trademark, the consideration would be if it is a consumer product, you should consider filing in China as a protection for yourself. I hope that answers your question.
Yeah, the other thing I would say to Mohan is that apart from the IP side of it, there are protections that can be written into manufacturing agreements that should be written into them, depending upon where the manufacturer is. But even working with China, which tends to be sometimes more difficult, it's important to make sure that you've got the right language in your agreements to protect you. And as Quan was saying, you may want to look at other alternatives as well. Even in Mexico, you can find some lower cost manufacturing that can be closer to home. It depends what it is you're manufacturing, but definitely you want to look at both the IP regulatory filing side and also your agreements.
Very good. Richard, thank you. Any questions you may have, please go ahead and post it. A follow-on question for you, Quan, on this, and maybe Ken as well. So you can get all these patents in the different jurisdictions, as you mentioned, but at the end of the day, you need to enforce it, right? I mean, maybe you could talk about that a little bit, because so should you go after all these patents if you can't enforce it? What are they good for?
Yeah, love that question, because it's something that I tell our folks all the time, so that we can set expectations and knowing what we get ourselves into, right? Patents are really expensive, especially in foreign jurisdictions. You're looking at, just to start, $10,000, and then it adds and adds and adds. And by the time you're done with it, just one family or one country is $100,000. Just think of 10, right? So the rationale for a startup to file a patent application and to eventually get patent is not to enforce, is not to sue anybody. The average cost of getting just to the steps of a courthouse is about $500,000. It's hard enough for a startup company, to raise, $100,000, much less $500,000, $500,000, so on and so forth. So the resources of a company should not be used for enforcing patents. So then why on earth file patent applications? It has to do with asset valuation. It has to do with building assets for the company. So when, let's say, a Johnson & Johnson is going to acquire the startup company, they would want to know, two reasons. They want to know, when they put money into the company, is Johnson & Johnson going to have a monopoly on the technology or not, or there are some other competitors that's going to be doing the same thing. That's one. And with that, then, they know that Johnson & Johnson can afford $500,000. It's a drop in the bucket for them. No big deal. They're the ones.
Because they could do it, right? They could do it. That's why.
Exactly. But they want to see those patents. And because you have those patents, you build asset for the company, and you can ask for a premium on the exit because you have those patent assets. Now, a player like Johnson & Johnson, they're not just a U.S. company. They are a global company, and they've got marketplace across the world that spans many countries. And so then they would want to have enforcement capability in Europe, in Canada, in Mexico, in China, in Japan, and so on and so forth. And so if you have those assets and you have invested in filing in those countries, then you can ask for even more, because then Johnson & Johnson or the like would know that then they would have protection and ability to control the markets in those areas. So to answer your question in brief, startups should not file or think that they're going to file patents because they're going to go sue somebody or enforce somebody. They should think of it as an investment in their asset for an exit for a better valuation.
That's not to give you a compliment, Quan, but that's probably the best answer I've heard when it comes to this. That it makes a lot of sense. Richard says they just filed the PCT application, and your answer is quite relevant. So, all right. Okay, let's see what other questions anyone has.
So if there are no other questions, or there are some questions, let me know. But what I would like to do for the next few minutes is to dig deep into the areas of IP that I laid out at the beginning, like an outline of an IP due diligence. So tracing ownership is one. Let me just summarize them. Tracing ownership is one. Looking at patentability is two, whether you can or cannot get a patent eventually because you're only at a pending stage. Having an issued patent is three, whether it's going to be valid or not, if it's going to get challenged. And the fourth one that I want to bring up is alignment. The word is alignment. Whether it's an application, and more importantly, if it is an issued patent. This is what happens a lot, is that when a company first starts out, a seed of an idea, it's a great idea, and it's for the time of 2015, it was the best idea. And they file the application and they get a patent on it. And now it's 2023, 8 years later. Well, innovation is about change. Innovation is about improving. Innovation is about doing things better, right? So the original seed of the patent or the original seed that was used in the original filing that has now matured into a patent may no longer reflect or align with the technology that is being practiced today. So it's irrelevant, right? So what you want to look at for due diligence is that fourth factor, the alignment. If it is aligned, wonderful. You look at the product that is being commercialized these days, and you look at the patent claims that are either issued patent claims or pending application patent claims, and you make sure that they're aligned. If they are aligned, great. If they're not aligned, let's make sure that they're aligned. Okay, so those are the four. I want to go back to the original ownership issue. This is really important for startup to realize, or anybody to realize, but especially for startup. Inventorship is key. Okay, so the definition of an inventor in a patent is it's cut and dry. There's no, just because you're an investor, you don't get to be an inventor. There are mechanisms to take care of the investors without having putting the investors on as inventors. If that happens, the patent may end up being invalid. Okay, so an inventor is someone who intellectually contributes to the claim of the patent. Okay, so that is the bar, but I'm not going to go into that detail right now. Now, there is all you need to know is that there are specific requirements to be an inventor. And here's the next thing. When one is an inventor, one automatically becomes an owner or a co-owner. So if you list three people, all three of them are co-owners because they're co-inventors. Automatically, they will become co-owners. Okay, when they're co-owners like that, when a company is looking to buy that company, the startup, one of the challenges, well, if I buy it from this one person, let's say one person assigns it to the company and the other two have not. The other two technically can go sell it to a competitor. Okay, so this whole thing about inventorship is tied to co-ownership, and it's really important that all of the inventors assign it to the single company that they are all working for. Because if there is a missing assignment, that means that the person who did not assign can go sell it to a competitor, and an investor or an acquisition partner is not going to entertain it. And there are situations like that, big ones. Okay, and with something like that, it is much easier to take care of at the very beginning, because when there's no
It's
money at
way
stake,
easier to take care of it in
way
the beginning.
Yeah.
easier, no money at stake.
Yeah.
When you're looking at $100 million acquisition, there's going to be a holdout. If the person has not yet assigned, that person is not just going to assign. Give me more is usually the demand before I sign, or
Right.
I'm going to just like kill the deal.
Right.
So take care of that thing. So I just wanted to touch on that part of the tracing.
And
Of,
is that a transaction that someone like Ken would do and not you, the actual assignment? So is
it's
that
both of
a
us. It's
Uh,
both of us. We have to make sure that these things are in place. Ken, your answer.
No, no, I agree. I would I've done that type of work, and I always work with an IP attorney to make sure that all the ends are taken care of. And of course, the question comes up: what happens when the person who didn't assign passes away? How do you clear title?
Right. And that has happened. That has happened. You look at the contract. Hopefully, missing an actual assignment, there's a contract in place already. Because IP is like it's intellectual property. It's not real property like a chair, a table, things like that. A chair, table, you can usually think of it as in the wills and trusts. It goes down to your relatives and whoever you will it to. IP is the same thing. Then you go after, not go after, you look for the person who's responsible for the estate, and you negotiate with them. Hopefully there's something at the beginning of the company that says that all the folks who are part of this company agree to assign whatever it is.
everything?
Yeah, you can go with that, but yeah, it has happened. It becomes really, really difficult.
We've had situations where a startup will sometimes add somebody's name to the filing just as a gift. They're just trying to be nice, and they don't realize what they're doing when they add additional people, and they lose track of them, and it can kill a deal.
Yeah, it can.
So I could tell you from a strategic standpoint, when we're looking at these and we see that a patent is not assigned, and then the co-owners will say, "Oh, we'll assign it when a deal happens." Then we're going to tell them right up front, it's not going to go through. You need to assign it before you actually enter into a deal, because that might kill a deal while you're holding back, and that's going to really have the investors or maybe potential acquirer wonder why you're doing this.
No, that's right. And to the point that I was making earlier, if they don't assign it in advance, when it comes to those representations and warranties that are contained in every agreement, and you're repping and warranting that you've got good marketable title, you've now breached the representation.
You don't.
You don't.
Yeah. All right. We have a question here from Sanjay. That's for you, Kwan. Go ahead.
My client Sanjay, how you doing, my man? So happy that you're on. Sanjay has a shout out to Sanjay. He has an incredible water tech company, water leakage detection, and so on and so forth. So, my man Sanjay, what is this? Patent can get expensive for early startups. How do investors feel startups? How do investors feel about startups using some of their investments for patent strategy, where there could be a risk of not being successful with a grant? So that is usually the ask from startups. Where they say, well, yeah, this is all we've got, and we can use some money to build out our IP some more. The question is very much about how investors feel. So I'll defer a lot of it to you, JJ. So why don't you go for it? I have my own thoughts, but you go for it.
No, go ahead. Go ahead. Continue. I'll continue.
Oh
after you're
yeah,
done.
I think. Well, so I'm a patent guy, right? So I want the best for our clients, and the sky's the limit for this, and get really expensive. So I do advocate for the investors and help work with our startups. I do work with them to build a case to present to investors that here's what we've got. We've got good IP, but we can build it out more if there's more funding, and this is the approximate cost. That's what I usually try to do, so that the investors will see the value in building out the IP. And like I said at the beginning, is that if there is a failure in the startups in which 90% or more fail, then at least there's the IP part of it that could be of some value for a fire sale. So that's my answer. Anybody else, JJ?
So I will say, so this is what I see a lot of times, and uh, a lot of times what I see is companies, they come in either looking for help from Pismo Ventures or looking to get investment from Pismo or Tecos Angels, where it's a group I belong to as well, and they have 10 patents, but they have no technology. They haven't built anything, they haven't done anything, they just have the patents. So that's completely kind of going the other way and not doing anything and just filing patents. And so in my opinion, that's useless. You just do a bunch of patents and you don't have a business, you just have a patent portfolio. The likelihood of selling that patent portfolio is almost zero by itself. So build a business, and I think what Kwan was saying is right, is build that business and then say, I do have patents. You can always, and again, I don't know, how all the patent stuff works, Kwan knows, but you can start a provisional, or you could do, Kwan the other day told me about a strategy when it comes to patent. You can try to go and file for patent and also not publish it, and so that's also another potential strategy. But again, don't spend all your money on the patents. Spend your money building a business, because the investors are going to invest into the business. They will not invest into a patent portfolio. But if you do have a business and you are going to build a patent portfolio, you could, either from the money you're going to get, it's going to be invested in, uh, then yes, the investors are going to be happy that you have some moat around your business, but build the business as much as you can first before concentrating fully on getting a bunch of patents. That's kind of my 2 cents.
Totally on board with that. So building a business, part of that is that you've got a widget that works. That's how you have a
That's right.
business
You
to
got to
begin
have
with.
something.
Yeah. So the patents could be filed. The good thing about patents, the patent system, as opposed to a peer review academic publication, is that you don't need data. You don't need to show and prove that it works. So there's no check valve to know whether, when you have a patent, it works or it doesn't work, or works well or doesn't work very well. So if you have a business, therefore, in doing well, then you must have a widget that does something properly. And then if the widget is protected, if the widget is doing well, then it should be protected and protect some more. So from there, the basis is to have something that works, and then patents could reasonably flow from there, but
Not
not
just the
from.
widget, not just the widget. The business has got to work for the investment to happen, right? So
Right, right. The only exception to that, though, Kwan, might be if you have developed a piece of intellectual property that's usable by other companies, you can license that, and in some ways you can capitalize your operation by licensing the technology that you've got, and it's a non-equity capitalization. It doesn't dilute anybody. It's just cash to the company. So it doesn't happen frequently, but I have seen that happen where somebody just managed to um, encapsulate a technology and sort of know where it needs to go, or who the established companies are that will want to have that license.
I agree, but yeah, 100%. And a licensing strategy is a great strategy if you have something, especially a consumer product, right?
Mhm.
Where there are, some huge companies that are in the space. you license it to them, and you could make a lot of money. Again, it's you don't see as many of these, but it's potentially really. I have not seen many investors invest in this type of strategy from an investment standpoint, but it is definitely a great strategy for a licensing type of deal for
Yeah.
sure.
But I guess what I'm hearing most is that it's not a one size fits all answer. You've got to look at the company. You've got to look at what the core assets are and the value of those assets, and then make a determination based on your company and its financial condition, and not just file for the sake of filing.
Yeah, the other thing, I'll let you go, Quan, in a second. The other thing I would say is also it depends on the type of company. So yeah, there's no one size fits all. But if you're a life science company, that's one different ball game than you are a software company or maybe a widget company that's building something, because someone can create a variation. Life science company, patents may need to be done upfront ahead of time, because it takes a long time to get to a solution that could be acquired by Johnson and Johnson or Stryker or somebody, right? So but for other types of company, maybe technology, non-life science, you'd have to weigh the options at that point. Go ahead, Quan.
Yeah, so actually, I'm going to bounce it back to Ken. You'd reference, I'd reference assignment, and you'd reference licensing. Just to make sure that our audience, the startups, understand, can you explain the difference between the two, licensing and assigning, so that our audience can understand the differences?
Well, an assignment is a way of moving the ownership of whatever you're assigning from your company or an individual to another company or an individual. Assignment is really just a fancy way of saying a transfer or a conveyance. Licensing is where the company that owns the technology keeps those rights, and they are usually by way of charging a royalty of some kind, sort of renting the ability for another company to use that technology themselves. And that license can be either exclusive, which means that you agree that they'll be the only entity that can use the technology, and you won't give any rights to anybody else. Or it can be non-exclusive, where you say, well, I'll license you the rights to use it, but I'm also going to retain the right to license it to multiple other companies as well, perhaps broken up geographically, perhaps not, perhaps in a competitive way. And so tend to think of it as a sale versus a rent of whatever it is that you're either assigning or licensing.
Cool.
Very interesting. Talking about this, when it comes to university technologies, they usually try to, because they're not trying to build the business, they want to have somebody else build it. They usually try to provide the business with an exclusive worldwide type license. That's what I've seen in general, so that the company can build, whoever's licensing it from the university can build a real business around it. Otherwise, because it takes a long time to build a business, it may not be worth it if they don't have an exclusive perpetual type license.
Yeah, but you've got to be careful there, JJ, because there are traps. For example, if you are funded by a particular university program, frequently if you're funded by a government agency, they may retain ownership that you don't realize that they have until they're ready to assert it. And you believe you've built it using their capital. They've given you a grant or something, but you didn't read the fine print. And by the way, they have a perpetual ownership interest in whatever you build using their capital. So
Absolutely.
you really have to be very careful and go through it with people like Juan that can make sure that what you're getting is what you think you're getting, and you're not giving up something that you're going to wish you didn't later.
For the audience, go read up on Moderna. The government tried to do a march in with the patents that they supported. all the COVID and vaccine stuff like that. Big deal. Check out the Moderna situation.
Wow, that's amazing. Well, okay. So some people are asking if this is recorded. Yes, so this is recorded. It will be available both on LinkedIn and YouTube. So if you can go back to LinkedIn wherever you joined, it'll be there and it's recorded. And also, if you joined from YouTube, it's also recorded on YouTube as well. Well, it's the bottom of the hour or at the end of the hour, whatever that may be. Thank you guys for the due diligence and the IP and the legal, advice that you provided. I think that was very valuable. I think we will reconvene hopefully the second Tuesday of every month. And so we will see you then. I'll make an announcement before we end. One is, so we have the Startup Symposium for non-life science companies. We started registration about 2 weeks ago. So this will be for November 16th. So it takes time to fill out the application, sign up, and fill out the questionnaire. So please, if you're interested, please go to pismoventures.com and click on the event link, and that'll take you to there, so you can get started from there. And any other announcements from Kwan or Ken?
Nope. Other than that, now I have to get back to work. I mean, this was so much fun. I'd rather do this all day long. But I gotta go back to work now. Darn it.
All right, Ken, anything from you?
No, I just glad that everybody participated and hope it was worthwhile, and look forward to continuing this dialogue.
Yes, please, if you have any questions for Ken, for Kwan, or myself, the emails are on the screen. Please feel free to reach out to us. I would be happy to help. Thank you very much, and we will see you all next time. Bye-bye.
Thanks, JJ, for putting this